we are at our final speech of the day. Now, when we talk about ocean conservation and protecting animals, and also when we talk about people, fisheries and everything, we talk about human rights, animal rights, and all those things. But how often do we talk about the rights of the ocean? So to talk about this interesting topic, we have Professor Kokila Konasinghe, Senior Lecturer, Department of Public and International Law, and MPhil and PhD Coordinator of Faculty of Law, University of Colombo. And she is the founding director of Center for Environmental Law and Policy of University of Colombo as well. Also, she is currently involved in 2 SAARC regional level projects representing Sri Lanka. So Professor Kokila Konasinghe, the stage is yours to talk about ocean as a living entity, a shift of paradigm from legal personhood to legal naturehood in claiming rights of the ocean.
Hi, Boan, and a very pleasant evening. And it's my honor and privilege to join this forum where I feel the odd one out. Because when Alosha asks who has gone 5 meters, 10 meters down in the sea, I thought that there will be only little, so I am all right. But ever since everybody else, the hands went up, not me, I think I have a lot more to learn, Alosha, from you. And also, I feel very much like a Lilliput among the giants, because I absolutely don't know anything about marine biology, fisheries, the coral reef research, and also fisheries community. I am purely from legal, and I have done only legal research. Therefore, in a way, that I think I deserve to be the last speaker. Now you know about the ocean and all the aspects, dimensions of ocean conservation and the areas that need attention. So my aim is that to talk about the right-based approach to protect the ocean, which is quite different to what we have been listening so far. Now, as a lawyer myself, I think when a dispute comes out, there are various methods that we can apply. We consult to go to magistrate court, we consult to go to district court and get compensation, fine, and also sometimes imprisonment. So there are various remedies. Today, I'm very pleased to talk about a different approach to what we have been coming so far. Now let me tell you, there are 2 methods of making legal standards with reference to environmental protection. One way that has been very popular so far is the anthropocentric approach, which means when we make laws, standards with regard to environment, then we look at what benefits the humans have, and also what entertainment that we can have, like the pictures of Nishan that I really adore that he took those pictures. So, so what benefits and what entertainment, and also how that can be impact upon the human beings. So the human beings are the central focus in the anthropocentric approach. There is another approach which is not quite popular so far, but I think the future lies there. That is the ecocentric approach. That means we have to consider humans as just another species in the whole ecosystem. So we do have rights. So does ocean. So does the forest, trees, rivers. So that is what I'm going to focus, the ecocentric or the biocentric approach to environmental protection. Now, it's a very interesting discussion in the legal scholarship today, because so far we have always been argued through anthropocentric approach, human-centered focus. But now we are slowly moving with the climate change challenges coming up. We now try to begin to think that whether we have done the correct thing so far. So now we are looking at humans as just another spot on the big map of the ecosystem. Now the question is that enough? Is that enough? Because with the ecocentric approach also, we have now, so far, what we have done is, we argue right to clean environment, right to clean water, right to live in a healthy environment. Again, we are coming back to the square, and then we say, we must have right to clean environment. We must have clean air to breathe. So again, the focus is going around us. So we talk about right-based approach to environmental protection, but we think only about us, humans. Now there is an interesting movement, I would call, all around the world, called Rights of Nature movement. Perhaps, Alosha, you will be one of those right-based approach and also rights of nature movement revolutions in the future. So this is actually for the younger generation, I'm telling. This whole concept of rights of nature says. Now, when I was thinking about an area, and Senali kept asking me what area, what title are you going to talk, then I had a look at of your poster, the flyer. It says, protect our ocean. Now, I am saying, according to rights of nature, that's a wrong statement. Why? It's not our ocean. There's nothing in the nature belongs to us. Therefore, they are a living entity, a different entity, so are we. So we have to live in harmony with each other. So we cannot protect our environment, our ocean, our trees. It is a different entity. So that kind of approach is all about right of nature approach. This concept, now you may see as a ridiculous argument. For me, it is. Because for a lawyer to go before the court and argue for your rights, you must have legal personhood. So you must have rights and obligations, responsibilities. Can the nature do that? No. Because now, so far, we haven't had any argument built up towards giving the nature a legal personhood. But the happy news is certain efforts have been tried all around the world in terms of passing legislations, statutes, acts, laws in the parliament, and also giving very progressive judgments, and also, interestingly, guaranteeing a constitutional provision. Any country, the constitution is the supreme law. So all these avenues have been tried out by the right of nature approach to protect nature. Let me tell you a few examples. In New Zealand, there is a river called Whanganui. So this Whanganui river is mostly the livelihood of the indigenous communities, Maori, was settled down in this area of Whanganui River. And in 2017, the New Zealand Parliament passed an act, Whanganui River Settlement Act, where they recognize Whanganui River as a separate legal entity that can anytime go to court and say, I have a right to be protected, I have right to be restored. So this act, particular act in New Zealand in 2017, introduced actually the concept of rights of nature. In India, there are two rivers, Ganga and Yamuna. Uttarakhand High Court gave an excellent judgment. They said that river Ganga and Yamuna has right not to be polluted, just like an average human being. So this Uttarakhand judgment is recognized all over the world by legal scholars. Unfortunately, there was this argument at the Supreme Court at the appeal level, which turned back this judgment by the Supreme Court, because there was another argument, interesting arguments put forward, because to anyone who has legal personhood should carry liabilities and responsibilities as well. So the defense lawyer asked, if river Ganga or Yamuna flooded and killed human beings, can river Ganga and Yamuna hold liable? So for us, I think those who are passionate about nature and consider nature as another living entity, this is no surprise, because this is not an argument that can be put within the context of nature. Therefore, that judgment was different at the Supreme Court, but all over the world, this particular Uttarakhand High Court judgment is recognized as some way forward with rights of nature movement. Finally, Ecuador Constitution has guaranteed rights of nature. They consider nature as something alive. So these actual situations and all the examples that I brought forward can use as to build up some arguments with the ocean as well. As each one of you pointed out, and it was reiterated by every speaker, that the ocean is a living entity. It has so much life into it. And also one other thing that every speaker emphasized was that there is an interconnection, interdependent with human beings and all the other sectors of ecosystem. So we have to live in harmony. There's no choice. So I think with this, the legal personhood, the parameters are no longer valid. So as an advocate in human rights of nature movement, I would say that we have to find new ways, new avenues for future. And also, I would like to stress here that rights of naturehood instead of rights of legal personhood, rights of naturehood. So we have to look for new concepts, new avenues, new legal arguments, strategies to overcome this barrier. In 1972, 50 years ago, in California Law Review Journal, Professor Christopher D. Stone wrote an article. The title of the article was, "Should Trees Have Standing? Toward a Legal Right for Natural Objects." And that was a laughable argument in 1972. And in that article, I quote Professor Stone, "The fact is that each time there is a movement to confer rights onto some new entity, the proposal is bound to sound odd or frightening or laughable. This is partly because until the rightless thing receives its rights, we cannot see it as anything but a thing for the use of us who are holding rights at that time." So we have to revisit, we have to rethink, and we have to find new avenues and new ways of addressing this rights of nature approach to ocean conservation. So with that note, I will conclude, and thank you very much, Blue Resources Trust, for inviting me, and thank you so much. Have a lovely evening. Thank you. Ayubowan.